Well, good afternoon, Michiganders. It is Tuesday, February 16th, halfway through the month of February already, 2021. And, of course, this is Tuesday with Tom, Michigan's only weekly internet show where we do answer your questions about estate planning and estate settlement in Michigan, and we don't send you a bill. I'm your host, Tom Doyle, estate planning attorney, lifelong Michigan resident, and ambassador for all things good in this great state of Michigan. Welcome, welcome, welcome to today's program. Well, last night here in mid-Michigan, we certainly received a fair amount of snow, and on the ground now we've had more snow than I've seen in the last couple years. Of course, last winter, as you probably know, I spent it in San Francisco. So I missed all of the snow last year, but we certainly received a good amount of snow last night during the nighttime here in mid-Michigan. And if you haven't listened to the program for a while, a reminder, too, that you can now search the 200-plus podcast about estate planning and settlement. Simply go to the TuesdayWithTom.com website, and you can use the search feature on the website to find answers to your questions about estate planning and estate settlement here in Michigan. Well, last week's episodes, 6 reasons to reject an inheritance. And perhaps you never thought about it, but in some cases, you might be better off rejecting an inheritance. And so I discussed 6 times that might make sense for you. Well, that leads into today's show. Today's show, we're going to talk about how to reject an inheritance. So if you're looking at perhaps being a beneficiary on a retirement plan or some real estate or bank accounts or whatever it is, and you don't want to receive that inheritance, that's what we're going to talk about. Today's show is how to reject an inheritance using what lawyers call a disclaimer. But please remember, what I'm about to discuss during the program is for educational purposes only and is not intended to be legal advice. As always, you need to work with your attorney to determine what is appropriate for you and your estate plan. And what I actually decided to do today, I'm taking a clip from a previous Tuesday with Tom's episodes back in September 2019 when I discussed the same topic, and so I'm going to play that clip for you as part of today's program. Just say no, or how to reject an inheritance. So this morning we're going to talk about disclaimers, what they are, how they work, and what they're used for. Let's think some examples. Had a client not that long ago that spouse died, had a substantial IRA that the spouse, the surviving spouse, was the beneficiary on. Well, the spouse didn't need the money, had a sizable estate of her own. And in fact, if she received the IRA herself and then died, she could end up with a federal estate tax problem. So what was the solution? Well, a solution was for her to disclaim it. And by disclaiming it, what ended up happening is the IRA then went to her children, who were next in line after her, which is where she wanted to go anyhow. So rather than having it go to the spouse, and then the spouse turning around and giving it to the children, she simply did disclaimer, then the IRA was going to go to the children, and that also allowed the children to have some stretch options that they otherwise would not have potentially had, certainly if she cashed the IRA and gave the proceeds from the IRA to her children. Another example, joint owner of property. I jointly own property. Let's say, better example, client dies, couple children are now supposed to be the joint owners of their property, and one of them just doesn't want it. They don't want to be involved in it. They don't want to deal with it. They don't need it. In that case, they could disclaim the joint ownership, and that would be then treated as though they had predeceased and were not just have predeceased, but they actually gave up any interest that they would have in the property. It would be owned by the other owners at that point in time. Another example, life insurance. Maybe you're the beneficiary on a life insurance policy and you don't need the money, you don't want the money. Maybe there's an alternate beneficiary on the life insurance policy. You'd rather have them get the money. And so you can disclaim the life insurance policy proceeds, and in that case, the proceeds would end up going to either the other primary beneficiaries if there are, or would go to the alternate beneficiaries if there are no other primary. So the idea is that you do not have to receive an inheritance. You don't have to receive money from an IRA. You don't have to agree to jointly own someone because you can give up your ownership interest in it. You can disclaim an inheritance under a trust. You can disclaim perhaps a distribution that's going to be made to you under a will. You can disclaim any interest that you might have under an estate under intestate succession. So the law basically allows you to say no. And in Michigan, it's part of our EPIC laws, and it's called a disclaimer of property interest law. And essentially, what that does is it creates the right to disclaim, to basically say, I don't want it. Now, a disclaimer can be total, I don't want any of it. A disclaimer can be partial, I only want to receive half of it, or a percentage of it, whatever it happens to be. And then who can disclaim? Well, you, a person, can disclaim. A fiduciary can disclaim. And who would a fiduciary be? For example, an agent under a power of attorney could disclaim receiving something. A trustee, if the trust gives authority to the trustee to disclaim, which normally ours do, because we never know, there might be reasons that a trustee says, I don't want the property. Let's say, for example, it turns out that we've got property that's supposed to go into your trust, but the property has an underground gas storage tank. Well, in that case, the trustee is not going to likely want that property because of all the environmental issues that go along with it. And so normally our trust will have language in them that allows a trustee to say, no, I, as a trustee, am not going to receive the interest in this particular property. So what is it? What does it have to have? Well, under Michigan law, it has to be in writing. That makes sense. You can't really have an oral disclaimer. It has to be in writing. It has to describe what the interest is that you are disclaiming. It has to affirmatively state that you are disclaiming it. And you, as what would be called the disclaimant or the trustee or whoever it is that's going to disclaim it, has to sign it. And then finally, there are different statutory periods of time that the disclaimer has to be done within. And so you have to really look at the Michigan statute, depending upon what the assets happen to be, to determine what is the appropriate time. But there are time limits for a disclaimer to be effective. And if it's a federally controlled asset, such as an IRA, IRAs are controlled by federal law, then there are federal guidelines that require that the disclaimer be received by the transferor. That would be the person that you are disclaiming the proceeds from, if you will, or the representative. Maybe it's Merrill Lynch, they're managing the IRA, whoever it happens to be, or the trustee, if it happens to be a trust that the asset is coming from, but you only have 9 months. If it's from the date of death, you only have 9 months in order to provide that written disclaimer to that individual. Or maybe someone's making a gift to you. You only have 9 months from the time the gift was made in order to disclaim it according to the federal guidelines. But there is a process. That's why you need to work with your attorney to make sure that you're following the process appropriately. And then, so what happens? What happens with an asset once someone disclaims it? Well, essentially, the asset then passes as though the disclaimant failed to survive. So let's say, for example, I'm the beneficiary of a trust. And the trust says at the time of my parents' death, the estate is to be divided between my 6 siblings equally into 7 parts because I'm number 7. So the trust says, upon my death, divide the estate equally between my children. There happen to be 7 children. I could disclaim my inheritance under the trust, and then the assets that would otherwise have gone to me are going to go wherever the trust says they will go if I fail to survive. So, for example, if the trust says equally divided between my surviving children, if I disclaim it, it will be treated as though I predeceased, and in that case, the trust would be divided between the other 6 children. On the other hand, the trust might say, if a beneficiary fails to survive, then give it to his or her children. And in that case, it would be treated as though I had failed to survive, and my share would then go to my children. Similarly, whether it's an IRA, in that case that I told you about with the client, when she disclaimed it, we already knew that the alternate beneficiaries on the IRA were her children. So when she disclaimed the interest in the IRA as the surviving spouse, it was treated as though she had predeceased the individual, her husband who had the IRA, and then the proceeds simply went to her children. So that is essentially where the asset is now going to go. So there is some strategy that can be used. And sometimes what's going to happen is when you're putting together your estate plan, it can be important to give some thoughts to the possibility. And you might create, if you will, sometimes an estate plan and a provision with the thought that, well, maybe somebody is going to want to disclaim this inheritance or this IRA or this life insurance money, whatever it happens to be. And we think about that and, quite frankly, plan for that as part of putting the estate plan together in the first place. Now, another requirement, though, for a disclaimer is you have to disclaim it before you accept the asset or accept any benefits after knowledge that the asset is supposed to go to. So you can't wait and then receive the inheritance and then say, oh, by the way, I want to disclaim it. Or you can't wait and receive the IRA money and then say, oh, I want to disclaim it. It needs to be done, an appropriate notice given within the timeframes of the statute before you receive the asset or any benefit from the asset after you know about it. Now, for example, let's say someone made you a joint owner on their real estate and you didn't know about that at the time. Well, once you have actual knowledge of that, then you have to make sure that you had disclaimed before you actually had confirmed receipt of the asset. So you can't take advantage of the asset and then say, oh, I've changed my mind. It all has to be done, quite frankly, before you're taking any advantage of the asset. So let's think about some things that maybe disclaimers might be used for. One, it might be to avoid federal estate taxes. Federal estate taxes aren't so much a problem for many, many clients today because of the increased federal exemptions, but maybe It's a situation, again, where I talked about previous spouse. By receiving the asset, my estate's going to be large enough that I'm simply going to have a federal estate tax problem. If I disclaim it, the asset's going to go to the people that I wanted it to go to anyhow and avoids a federal estate tax problem. Maybe an IRA coming to a spouse, it's going to be in a higher tax bracket. Children are in a lower tax bracket. Spouse doesn't need the proceeds. And so disclaiming the IRA will result in the asset going to the children, who will be taxed in a lower tax bracket. Sometimes you just don't want an asset. Not everybody wants to receive things that are left for them. I know we generally are looking at children and talking about children, and children can't seem to get their hands on the estate quickly enough after a parent dies, but sometimes there are certain circumstances where a child or an heir simply says, look, I just don't want that. For whatever reason, you don't have to have a reason, you just don't want it, you can disclaim it. And it is an opportunity to do some post-death planning. We don't have too many opportunities to plan after someone dies what's going to happen with their estate. We normally think that's all set beforehand. We have a trust and we put beneficiaries on the trust before we die. Or we put maybe a POD or a TOD on an investment account before we die. Or we put a joint owner on real estate before we die. All those things we normally think of as part of estate planning is done before we die. But it actually does give some opportunity to do post-death planning. And in the end, post-death planning is, in many cases, better than pre-death planning because now we know. We know what the estate consists of. We're not guessing how much money is going to be left in the bank account. We know how much money is in the bank account. We're not guessing at how much money is going to be left in the IRA because we know how much money is left in the IRA. And so in many, many cases, using disclaimers as part of a post-death planning can give some options that maybe weren't necessarily available in the pre-death planning, or we thought about it as part of pre-death planning and said, hey, we want to give our heirs options after we die to change our estate plan, and we think about that as part of a post-death planning opportunity. Now, there's another thing that needs to be thought about, though, and that's Medicaid planning, because here's inevitably what's going to happen. Someone's going to say, oh, hey, I've got this 5-year look-back rule, and I can disclaim an inheritance, so maybe I'm supposed to receive an inheritance, but the inheritance is going to cause me to lose Medicaid, but I've got this 5-year look-back rule, so can I disclaim the inheritance to qualify myself for Medicaid? And the short answer is disclaimer of an inheritance to qualify for Medicaid is going to be considered a divestment, and then it's going to incur the normal divestment penalties. So you can disclaim. There's nothing that says you can't if you're going to be receiving something you're trying to protect Medicaid, but if there are going to be complications that go along with it because there are going to be divestment penalties involved. So don't think, quite frankly, of using disclaimers as some sort of a Medicaid planning type strategy. But again, think about this. You don't have to receive an inheritance. You can simply say no. You just have to make sure that you do it under the right time and in writing that incorporates all the other requirements of the statute. Well, Just a reminder before we finish up with today's program, of course, that Amanda and I, we'd be happy to talk to you about in settling an estate. Is it appropriate for you to reject an inheritance? How would a disclaimer work? What's a time frame for having disclaimers? And if you listen to next week's episode, I think as I'm sitting here, that's what I'm going to talk about next week. Today we've talked about the times to do it. Next week, I think I'll have a discussion about how you actually go about disclaiming assets. But Amanda and I would be honored to have the opportunity to talk to you, to help you through that process. Of course, we'd also be happy to help you protect your loved ones by putting together an estate plan that you have, perhaps amending a plan that you already have, or assisting you in generally the settlement or the administration of a trust or an estate. Head on over to the virtual office at doylelawpc.com. There you're going to find information if you're a prospective client, how we can help you out. If you're a current client, how we can help you out. As I've said before in the program, because of COVID, we're staying safe. We're not seeing people in the office at this point in time. We're doing everything online. So if you're looking at having us prepare an estate plan for you, that can be done online. If you're looking at updating a plan that we already have done for you, that will be available online. So if you have an interest, simply head on over to the virtual office at Doyle Law PC, and you'll see the many ways that we can help you out. Also, reminder, at Doyle Law PC, we have our legal store. Perhaps you just have a particular individual legal document that you need. Maybe I'm settling an estate and the bank tells me I need a new certificate of trust because this real estate is owned by a trust. You can go to the legal store and you can order online a certificate of trust. Or maybe all I need is my estate plan never had an appointment of funeral representative and I want to have one. Again, durable powers of attorney, healthcare powers of attorney, appointments of funeral representative, a number of legal documents are available at the legal store. Well, now that's it for today's show. As always, though, if you have a comment about the program, a topic that you'd like to have me discussed, or questions that you would like to have answered, please send me an email, tom@tuesdaywithtom.com, or mail me a postcard, Tom Doyle, P.O. Box 16066, Lansing, Michigan 48901. And please, we invite you, follow us on Facebook and Twitter. That would be Tuesday with Tom. Follow the office at Doyle Law PC. Remember, too, the program is available in the Apple Podcast, Spotify, Google Podcast, iHeartRadio, Spreaker, and many other channels where podcasts are available. And you can always ask your smart speaker to play Tuesday with Tom. Thanks again for spending some of your time with us today. As always, I hope that you have an awesome day and an awesome week in Michigan. Stay safe. Tuesday with Tom has been brought to you by the estate planning attorneys at Doyle Law PC. To learn how we can help you with your estate plan or with settling a loved one's estate, please call us today at 517-323-7366. That's 517-323-7366.